Hello, everyone, and welcome back to our YouTube news channel. Today, we delve into the world of legal developments that could have far-reaching implications for the power balance between federal agencies and Congress, and let's get started. In a potentially landmark turn of events, the U.S. Supreme Court is currently considering two cases that might signal the end of a 4-decade-long practice, allowing federal agencies significant leeway in interpreting laws passed by Congress. According to legal expert Thomas M. Boyd, the pivotal moment can be traced back to Justice John Paul Stevens' opinion in the 1984 case of Chevron U.S.A. versus National Resources Defense Council. Boyd, a former U.S. Assistant Attorney General under President Ronald Reagan, describes this as the starting point of what legal scholar Gary Lawson later termed a bloodless constitutional revolution. The Chevron ruling altered the landscape by allowing federal agencies to interpret laws they deemed ambiguous. Subsequent administrations used this decision to implement policies that often deviated from the letter of the legislation passed by Congress. In a recent column for the New York Post, Boyd highlights that after decades, the Supreme Court is now set to hear two cases that could potentially mark the beginning of the end of this revolution. He emphasizes that Article 1 of the Constitution explicitly vests all legislative power in Congress, not in federal regulatory agencies. Boyd points out that Justice Stevens' opinion allowed agencies to rely on the administration's views of wise policy in reasonably defining statutory ambiguities. Essentially, this gave the executive branch, including presidents and their appointees, the authority to interpret specific aspects of laws passed by the legislative branch. This interpretation, known as the Chevron defense, has been criticized for contributing to the unchecked growth of the administrative state. Two cases currently before the Supreme Court, Loper Bright Enterprises versus Raimondo and Relentless versus Department of Commerce, have brought the issues to a head. Both involve family-owned and operated companies engaged in herring fishing in New England, subject to the Magnuson-Stevens Act, which governs fishery management in federal waters. Notably, the National Marine Fisheries Service, NMFS, used the act to require these relatively small herring boats to carry federal monitors, a move that has triggered a significant legal dispute. What makes the situation more contentious, as highlighted by former Reagan Assistant Attorney General Thomas M. Boyd, is that the NMFS, without explicit statutory authorization, compelled Loper Bright and Relentless to cover the costs of these monitors' salaries. The NMFS estimated these expenses at a staggering $710 per day, sometimes surpassing the earnings from a day's fishing. The federal circuit courts, in both cases, ruled that the statutory silence on this matter constituted an ambiguity, requiring the application of the Chevron deference, the very principle that has allowed federal agencies wide interpretive powers for decades. As the Supreme Court took up these cases, they proposed a critical question for litigants: whether the court should overrule Chevron or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. Boyd notes that some of the court's current justices, who identify as constitutional originalists, have hinted at their perspectives on the matter. Chief Justice John Roberts, in his majority opinion in West Virginia v. EPA, expressed, "We presume that Congress intends to make major policy decisions itself, not leave those decisions to agencies," citing U.S. Telecom Assen v. FCC. The outcome of these cases could mark a significant shift in how federal agencies interpret and apply laws. We'll be closely monitoring these developments and bringing you the latest updates. Don't forget to like, share, and subscribe for more comprehensive coverage. Thanks for joining us, and until next time, stay informed.